government procurement contracts. He, however, notwithstanding his assertion that he was representing the interests of the bidder, did not produce any resolution which authorized him to appear. He's a director of a company, and he knows how companies act. He knows that companies act by way of resolution. He did not have a resolution from the Economic Empowerment Group to represent it. The inference that we drew from that was that he was attempting to advance his personal interests, and that is association with the fictitious company. We have already referred to the liability of co-perpetrators. In 196, the persons charged together are both actual perpetrators and co-perpetrators. They are the actual perpetrators with respect to the roles that they played in the acts that constituted the criminal conduct giving rise to the fraud. But they are also liable for the acts committed by their co-perpetrators, which were within the common design. The fact that he was appearing and ostensibly on behalf of the bidder means that he clearly associated himself with the fictitious. In the inference which we withdrew, as in the main judgment, was that in all the circumstances of this case, he associated himself with the grand plan to misrepresent the fictitious company which submitted the bid as a registered company. At all times, the ministry officials believed that they were dealing with him on behalf of a lawfully registered company. He was also seen at the launch. He has got his own explanation, which we rejected. He said that he attended there on his capacity as a politician, and that as a member of the public. But we observed in the main judgment that at the launch, there were two parties made the launch. The one party was the party which was associated with the delivery of goods, and the other was the government which was receiving the goods. The witnesses made the observation that he was clearly associating himself with the delivery of the goods and purportedly by the fictitious company. We also found that he is a director of Militech Investments, which received 200 million out of the proceeds of the crime. And as director of Militech, he was controlling its affairs and is criminally liable for unlawful receipt of these proceeds. The money was unlawfully traded on the black market, and clearly, as director, he must have been party to the decision, and in fact, he doesn't deny it, to trade the money on the black market unlawfully. The company, Militech Enterprises, was fined by the Reserve Bank, as well as Electric Private Limited and the other entities that received the money. The modus operandi in terms of the manner in which the money was used after hitting the accounts of Electric Private Limited and Militech was essentially the same. No record was kept of the money that of how that money was traded on the black market. No record was kept, or at the very least produced in this court, of how the money was used. It was not banked, notwithstanding the requirements of the Bank Use Promotion Act. We convicted him on the basis that, among other things, the circumstantial evidence in this case, the conscience of it, from the plethora of independent circumstances that we have outlined above, all pointed to the same conclusion, that he was part of the unlawful project with the requisite mens rea to commit the crime of fraud. We therefore found him guilty as a perpetrator, as a co-perpetrator. And we said the totality of the circumstances could not be explained on the basis of any other inference other than that he was a perpetrator. Now, the law regarding the sentence is as follows. In terms of Section 136 of the Criminal Code, any person found guilty of fraud is liable to be sentenced to either pay a fine not exceeding level 14 or not exceeding twice the value of any property obtained by him or her as a result of the crime, whichever is greater. In other words, it is possible for an accused person to be sentenced, the accused person convicted of fraud to be sentenced to a fine which is equivalent to 2 times his or her share of the proceeds. Or the accused may be sentenced to imprisonment not exceeding 35 years. The legal practitioners representing the accused persons and the state did not motivate the first option, that is that of imposing a fine which is equivalent to the accused person's share of the proceeds. I'm sure the decision was guided by the provision of the sentencing guidelines, or rather the criminal procedure sentencing guidelines regulations of 2023, which is statutory instrument 146 of 2023. The guidelines were promulgated in the year 2023 pursuant to the provisions of Section 334A of the Criminal Procedure and Evidence Act, Chapter 907, which empowers the Judicial Service Commission from time to time to convene a judicial conference for the purposes of formulating sentencing guidelines, which in particular provide for inquiries and investigations to be conducted by courts prior to sentencing for offenders, factors to be considered by the courts when sentencing offenders, the forms of punishment that may be imposed as alternatives to custodial sentences, and the principles and criteria which will assist in promoting consistency in sentencing and equitable sentencing. And Section 334A in brackets 1 of the Criminal Procedure and Evidence Act further provides that the sentencing guidelines shall be in the form of a table of presumptive penalties supplemented by other additional guidelines addressing such factors as the Judicial Conference considers relevant. And the sentencing guidelines apply to all criminal proceedings in all courts which conduct trials at first instance. And of course, the appellate courts as well, and they take that into account in reviewing the work of the lower courts. The object of the sentencing guidelines is to foster public confidence in the criminal justice system by, as I said, promoting consistency and promoting transformative justice in sentencing and eliminating unwarranted disparities in punishment of offenders. With that in mind, the sentencing guidelines were widely circulated, meetings were held, throughout the country where the sentencing guidelines were explained. It is therefore, the whole idea was to inform the public and to make people aware of the likely penalties in the event that they commit crime, thereby achieving deterrence. As a result, presumptive penalties are largely known. They are largely public knowledge. The sentencing guidelines are binding on the court or on the sentencing court. Previously, the court was at large, but of course guided by existing principles and guidelines of decided cases. What the guidelines have done largely was to collect all principles that have come up from decided cases and to put them in one compendium which is easily accessible. And of course, explain them and explain how they work. What is important to note is that where a presumptive penalty is prescribed, a sentencing court may depart from it, but it must give reasons for the departure. That, of course, was also aimed at promoting consistency. All courts are expected to have a starting point somewhere and then exercise their discretion in either imposing a sentence below the presumptive penalty and give reasons for it, or impose a sentence above the presumptive penalty up to the maximum provided in the penal provision, in this case 35 years, and give reasons for it. A presumptive penalty is described in the sentencing guidelines as a penalty expressed as a specific amount of fine or a specific period of imprisonment, or both, that is midway between an augmented penalty, which may be imposed in aggravating circumstances, and a diminished penalty, which may be imposed in mitigating circumstances. That is why it is a starting point, but which must be respected, which should be followed, and a court which departs from it must give adequate and satisfactory reasons for doing so. Now, from the definition of a presumptive penalty, it then becomes clear that in every case, the sentencing guidelines provide for two presumptive penalties with respect to each crime. Now, in the case of fraud, the offense for which the accused persons have been committed, a fraud is deemed to have been committed in aggravating circumstances if one or more of the following situations obtain. If the items or funds or property involved were of considerable value, the offense is considered to have been committed in aggravating circumstances. If the funds, like in this case, were not recovered, the offense is said to have been committed in aggravating circumstances. If the offender was in a position of trust, which according to the state applies, and according to the defense did not apply in this case, because they were not really holding the funds in trust, and we will give the accused persons the benefit of that. And if the offender was a holder of public office, which does not apply. But if the offense involved public funds, the fraud is deemed or is considered to have been committed in aggravating circumstances. So when, as I said, when these aggravating circumstances exist, the law provides for a presumptive penalty of 20 years. The other presumptive penalty is when is a diminished punishment prescribed for offenses committed under mitigating circumstances. The mitigating circumstances are listed in as far as determining which the presumptive penalty to begin from, is where potential and actual prejudice was insignificant, or that the offender voluntarily compensated the victim. In that case, the presumptive penalty is prescribed as 6 months, and the court may go up or down, or even impose a fine in appropriate cases if the circumstances of the case demand it, particularly if the mitigating circumstances are compelling. The case before us involves prejudice in the region, potential prejudice in the region of 87 rather 26 million US, about 26 million, which is being 30% deposit of the contract price, which was pegged at 87,757,168 United States dollars at the rate prevailing on the day. This is the amount that the government had initially agreed to pay for the goods required in terms of the presidential scheme. Treasury only managed to disperse 1.6 billion in Zimbabwe dollars, which it is not disputed was equivalent to $7,712,197, rather $7,712,197.10 United States dollars. This was because, as explained by the Permanent Secretary, due to financial constraints. We therefore find that the potential prejudice, the amount that could have been disbursed as 30% of the deposit, being the potential prejudice, was high, and the actual amount that was disbursed was also considerably high. So, to that extent, the offense was committed in aggravating circumstances. The bulk of the money was not recovered, as explained above, and for that reason, the offense was committed under aggravating circumstances. There was no voluntary reimbursement of the money, which essentially cancels one of the mitigatory circumstances they are provided in the table in determining the presumptive penalty to start from. And it is common cause that this money was disbursed by Treasury. It was therefore public funds, and to that extent, the offense was committed under aggravating circumstances. Therefore, the unescapable conclusion is that the presumptive penalty to start from is the penalty of imprisonment for 20 years. The first accused person gave evidence in mitigation. Largely, we have referred to his personal circumstances. He also said that he has properties. But by and large, he dwelled at length on what he said was the performance of the contract. The performance of the contract, Mr. Koto produced a sheet of paper, a piece of paper, which was on the letterhead of Black Deck Private Limited. Which was on the letterhead of Black Deck Livestock and Poultry Farming, but with a logo bearing the name Private, Black Tech Private Limited, and which purported to list how the expenses or how the money that was disbursed by the ministry into the Black Tech Private Limited CAPS account was disbursed. It was largely disbursed, yes, to certain companies, or under the pretext that the companies had been recruited as agents to supply goods, and it was some of it was disbursed to the lawyers who were representing the company during the performance or issues to do with this bid. But the bulk of the company, the money, according to that piece of paper, was disbursed in improving infrastructure at Colenso Farm. The issue that arose is the weight to be attached to that because it was not signed, it was not clear. In fact, it didn't say, it didn't speak for itself regarding who had prepared that document and when. And in fact, the first accused person throughout the trial, in steadfast, refused to account for this money. And this came in mitigation, and in the problem is that it was inconsistent with this position taken by the first accused person that the bulk of money during the trial, that the bulk of the money was traded on the black market to buy United States dollars. The state submitted that, in fact, if the money was used to develop the infrastructure at Colenso Farm, then it was clearly misappropriated, because that was not the purpose for which the money was disbursed. We are surprised that at this stage of the trial, Mr. Koto persisted with the argument that a contract came into existence. The view we take is that because the ministry disbursed money pursuant to a fraud, then all the monies that were disbursed pursuant to that misrepresentation was process of crime. There is no need to talk about a contract. Mr. Koto is a lawyer. He knows too well that only parties with capacity to act can enter into a valid contract. Black Tech Livestock and Poultry Farming lacked the capacity to act, and it could not possibly be a party to a valid and binding contract. Mr. Koto also submitted that the state has got a title deed for a property in the accused's name, but he did not go further to say why he was making that submission. We thought that he was making that submission to offer compensation, but he fell short of saying that, and which underscores the fact that there was no voluntary offer to compensate. In mitigation, the first accused person considered that public funds were involved. Under cross-examination by the state, the first accused person eventually considered that fraudulent documents had been used to secure this contract, to secure the tender, and he apologized to the head of state and to the people of Zimbabwe at large. Although coming very late, these criminal proceedings, it's still an apology. An accused person who believes in his innocence is entitled to defend himself, and it is also expected that when he realizes that he was wrong in denying the charge, he must still be given credit for acknowledging wrongdoing and extending an apology for doing so. He will therefore benefit for having apologized to the head of state and the nation at large. Mr. Koto gave us other cases, some cases which I don't need to repeat in this extempore judgment, but they will certainly be part of the written judgment in order to assist us in arriving at the appropriate. Silence. Mr. Koto submitted in mitigation that there's no reason for the first accused person to be made to suffer on his own, or perhaps with the second accused person, for this offense, because the state deliberately abstained from charging the other co-perpetrators. He did not mention, but clearly it was clear that he was referring to the other directors of Black Tech Private Limited. They are Ajne Kabisira, who clearly took part by submitting the bid. It is on record that she's the one who signed, who put a signature in the book where the names of the persons who were submitting bids on behalf of companies were being recorded. She did. Her name appears in that. Very well. That may affect other things, perhaps restitution, but it doesn't affect his moral blameworthiness. It will certainly be taken into account when we come to restitution. He was probably referring to Tinashe Chimombe, whom we now know was a de facto director of Black Tech Private Limited, the company which lent its credentials to the fictitious company in order to give the fictitious company the semblance of a registered company. We totally understand why Tinashe Chimombe was not charged by the state. His involvement only became known during the proceedings, and so from the circumstances of this matter, it is safe to conclude that he was not charged because the state was not quite aware of his involvement as a director of the company which lent his corporate credentials to the fictitious company. But his involvement, having been brought to our attention, will be taken into account at the right time. But the state has got the prerogative to decide, as we said in the judgment, who to charge and who not to charge. There are several considerations that the prosecutor general takes into account. They are not known. This court is not privy to them. But what this court is privy to are the current considerations, because those are published in terms of the Constitution. The prosecutor general considers the sufficiency of evidence and policy considerations. Policy considerations are up to the prosecutor general. So we don't know why Ajene Kabisa was not prosecuted. We always respect the prerogative of the prosecutor general, and we don't wish to be invited by Mr. Koto to comment on that. It will be literally interfering with the constitutional independence of the prosecutor general. The second accused person also submitted in mitigation. He did not give evidence, but submissions were made on his behalf. by his legal practitioners. That is perfectly acceptable. And by and large, we have recounted his personal circumstances at the beginning of this sentencing judgment. Mr. Mugia, who submitted first, gave us cases which we found very useful, and I don't have to go through them now because they appear in the sentencing judgment. But most importantly, he said that he said that the sentencing guidelines apply to this case. He urged us to be guided by the sentencing guidelines. We accept the submission. That is correct, because the sentencing guidelines speak for themselves. They say that they are binding on all sentencing judicial officers and courts. Mr. Mugia submitted that the second accused person is a first offender. I omitted to mention that as well with respect to the first accused person. That is admitted. In our law, I will come to the sentencing guidelines. That is a very important factor. He indicated that there was no possibility of reoffending. He undertook, well, he submitted that he had the authority to undertake on behalf of his client that the accused person is not likely to reoffend. Having been in custody since June 2024, he has learned the lesson well from the lengthy pre-trial detention. He's already detained, I believe, and this submission was based on the fact that he was accepting, as is required by law, to mitigate, on the basis that one is required to mitigate on the basis that they've been convicted. Not necessarily that they are happy about the conviction, but because that is the law. They are bound by the conviction. So he said the conviction as it is a big lesson to him. He's already been in custody for a lengthy period, and that has been a lesson. Mr. Mugia gave us background of the offender. He said described as a traditional man who grew up in the rural setup and is a typical rags to riches person, and who is largely unsophisticated, but he worked very hard for the station that he now occupies in life. He submitted that the second accused person did not premeditate this offense. I've already referred to his earnings, and Mr. Mugia said they are title deeds for the properties that we described at the beginning of this judgment. He, however, fell short of submitting that the accused person was willing to sell those properties to compensate Treasury. But we assume that is the reason why he was making that submission. But importantly, which is an important factor, Mr. Mugia submitted that the second accused person suffers from chronic illnesses which require constant medication. The chronic illness is hypertension, commonly referred to as BP, and that has required him to visit South Africa at least twice a year. He said that in the event that he's sentenced to imprisonment, he will not be able to actually travel to South Africa to receive the specialist treatment. Obviously, this was submitted with respect to to persuade this court to impose a sentence which may be below the presumptive penalty or not too far above the presumptive penalty, to be lenient in the sentence that we were imposing, because incarceration, he said, will adversely affect or negatively affect his health. This is an important factor which is always taken into account by sentencing court. People are not sent to prison so that they may then have their health conditions deteriorate. But he, however, did not submit that treatment for hypertension is not available in Zimbabwe. He was traveling to South Africa because he could afford it, but there's no suggestion that treatment for hypertension is not available in Zimbabwe. This is critically important because the chronic ailment was disclosed as hypertension. Mr. Mgia submitted that the second accused person played a minor role in this offense. The state does not accept that, but we will come to that. For the purposes of conviction, clearly, as I've already explained, the role played by co-perpetrator does not really matter that much as long as his conduct was within the common design. But he's correct. When it comes to sentencing, the role of each co-perpetrator becomes very significant, and the court is obliged to distinguish in sentencing between co-perpetrators, at least in that regard. The understanding is that co-perpetrators are liable to the same penalty, but the court, in the exercise of its discretion, is entitled to distinguish if there are circumstances justifying distinguishing. And that is the point that Mr. Mgia was making, and we accept that as a valid point in mitigation. Inside, by and large, the second accused person, together with the first accused persons, are good citizens. They have offended for the first time, but they have shown that they respect the law, because when this offense, or when Zach publicized that it was looking for them, they came and presented themselves to Zach. I'm sure this was submitted for the purpose of demonstrating that in this particular case, emphasis should be on rehabilitation. You are starting from the premise that they are law-abiding citizens. We have transgressed, and they can be rehabilitated. He admitted that yes, the offense is serious. Yes, public funds are involved. Yes, there was no restitution. He acknowledged that. We respect him for that. But he said they cannot really be, be considered to have been in a position of trust because they are not public officials. We have already said that we will give them that benefit. Mr. Magi weighed in with the law, particularly the implications of the sentencing guidelines and the implications of Section 196A. He explained to us that he accepts that within Section 196, you have got people who are associating with each other in committing a crime. But it must be accepted that in the process of associating each other with the same intention to commit the crime, they may play different roles. That is implicit in Section 196A. So when it comes to sentencing, yes, they are both liable for the same penalty, but there's room for the court to exercise discretion and distinguish between them. We accept that argument. He then said, this court does not really need to visit all the punishment for this offense on the accused persons. I hope I'm quoting right. But he says there was contributory culpability on the part of the victims. The state officials which handled this tender were grossly negligent because this was, in his view, not a complicated fraud. It is a fraud which should have been detected in its infancy and could have been prevented if the state officials had been more diligent. He said among the state officials was a lawyer who knows the law. He knows that, for example, a company which is not registered in terms of the Companies and Other Business Entities Act has no capacity to act. Why did he allow this thing to sail through? He knows, for example, that the whole reason for submitting documents is so that they can be verified. Otherwise, there would be no point. We also add that these documents were crying out for verification. The documents themselves speak. They say, verify us through the code. Verify us through the verification code. Verify us through the QR code. But it is a fact that that verification, that due diligence was not undertaken. But the witnesses explained that the documents were so convincing that there was absolutely, it appeared that there was no need to verify them. They were used to dealing with these documents, and they looked exactly, like the originals that they'd been dealing with all along. We understand the argument by Mr. Maduku, but we don't believe that it is a factor that we should really give much weight as mitigatory. There's everything to say about what went wrong for the ministry. But that is what fraud is all about. Fraud is all about deceiving. It's all about making things appear okay. And these are the ministry officials were convinced that these documents were in the absence of such conduct. They would like this. There was nothing. We are aware that there are so many gate pickers. We are aware of interviews. Mr. Koto spoke about circumstances where people attend interviews for recruitment for employment, and we all know that usually certificates that are submitted are accepted at face value, as long as they don't look suspicious. Yes, the officials could have done more, but definitely that cannot be a factor which an accused person can rely on so much in mitigation. We are not saying gullible people. If your victims are gullible, then that reduces the moral blameworthy of the perpetrator of a crime. We at least on this one, we do not agree with Mr. Matuku. He said we don't need to look at the prejudice because the state officials brought about this. Well, I'm sure that argument is self-defeating because the accused person submitted these fake documents, with the belief that they would be accepted, and they were accepted. So there's no contribution. They were just deceived. Actually, ironically, while condemning the ministry officials for leaving, we are surprised that even the legal practitioners who represented the accused persons at this trial believed throughout the trial that blackjack livestock poultry farming is indeed a legal person, and that this blackjack private limited, it is the same as blackjack private limited. I've already referred to the mitigation by Mr. Koto, which he persisted with, even in circumstances where the state proved that blackjack livestock and poultry farming is a fictitious company. He is still laboring under that misrepresentation. He's still so affected by it that he argued forcefully that there was nothing wrong. He still argued forcefully in mitigation that a contract came into existence. So why blame the ministry officials for being gullible when we have got legal practitioners who are privy to all the circumstances of this case, who still believe that a contract came into existence? That's the extent to which this crime was sophisticated. It was so properly thought, it was so carefully thought out and so carefully executed that, in fact, at the ministry, they were so confused that they ended up, describing the bidder by 4 different names. Some would refer to it as Black Dick Private Limited. Others would refer to it as Black Dick Livestock. Others would refer to it just as Black Deck. Some would refer to it as the person who drafted the contract referred to it as Black Dick Livestock. And that's how confusing, the method of operation was. And we therefore will not place much, weight on this submission that the fraud was not sophisticated. It was in fact sophisticated. The officers who testified on behalf of NASA and on behalf of Zimra said, these are employees of the organization board, said, by merely looking at these documents, they appeared perfectly normal, perfectly genuine. And they were only able to discover that they were counterfeits by scanning them. Other than that, they were perfect. And that's a sophisticated fraud in our view. So we can't really blame the state officials for being misled, because the documents used in this matter were carefully designed to mislead. The officer who gave evidence on behalf of NASA even went as far as saying it's difficult to tell how this was achieved, but all the same it was achieved. The official from Zimra said the same thing. It's difficult to say how this was achieved, but all this is. According to the official from Zimra, he said it is not possible for a Zimra tax clearance certificate to be issued to 2 companies. But somehow in this case, that appeared to be the case. In other words, that was made to appear to be the case, rather. How it was achieved, they've not been able to decrypt. That's how sophisticated this crime was. The state made submissions in rebuttal. To start with, they laid evidence on the impact of this crime. They called Alban Mindurwa to give evidence on this. A victim impact statement is described in the sentencing guidelines as a pre-sentencing statement made by the victim of a crime or other person, or presented to court the details of the physical, psychological, social, or financial consequence of the offense. To prove the financial consequence and the impact on the victims, the social impact, the state called Alban Mindurwa. He gave his evidence under oath, but essentially by reading from his from a victim impact statement which he had prepared and signed before a commission of oaths. He gave the background, which we have already alluded to. He gave the justification as that the scheme was identified as a catalyst for rapid livelihoods and improvement through commercialization of goat production and food security, nutrition security, and to increase income, and therefore realizing the aspiration of government policy vision 2030 and NDS1, which he did not quite explain. In this long term, smallholders would contribute to the growth of the domestic and export market. And goat production is one of the key climate-proofed livestock production in the country. He outlined the target groups as disabled persons, child-headed families, elderly-headed households, widow-headed households, and chronically ill or orphaned households. He spoke about the targeted status of the people, and he said he then referred to what we have already referred to in terms of the performance of the tender. He said the program is essentially collapsed. So far, there's been no movement, and the implications of the suspension are that have impacted negatively on the intended role of vulnerable groups and the collapse of this program has eroded public trust in government rural programs. They have tainted the image of the ministry and the government of Zimbabwe. They've affected the operational and budgetary already strained treasury. And he said the presidential flagship program has damaged the country's, the flopping of this presidential program has damaged the country's image. And either locally and internationally. We only need to add that it has also damaged the image of the head of state who was spearheading this program. He then went on to explain how it has affected the attainment of Vision 2030, and we don't need to explain to go into that because it's already part of the written judgment. It's on record. The state then made submissions regarding the guidelines and the application thereof to this case. The state alluded to what I have already referred to in terms of the presumptive penalty. The state acknowledged that ordinarily the sentencing guidelines require that where a fine is provided for, a court must start from that fine as a possible option, and only when it excludes the suitability of that fine as an appropriate sentence should move to other non-custodial options like community service. But having said that, the state submitted that the gravity of this offense is such that a fine would not meet the circumstances, the justice of this case. A non-custodial sentence would also not do that, because this offense was premeditated and carefully planned, because it threw everybody off the scent. And he suggested that the starting point should be the 20 years imprisonment. He referred to the prejudice, which he said was high. He also cited cases, but which relating to fraud. And in one case, the court, which is the case, in one case, which is the case of Catherine Chimombe, and another Harare High Court, 51 of 23, the court had this to say, fraud is a serious offense. Hence, the penalty ranges from a fine not exceeding level 14 to imprisonment not exceeding 35 years. And said, in refusing to set aside a prison sentence, said this particular offense was premeditated, complex, well-planned, and expertly executed. The state submitted that that was the situation in this particular case. The state referred us to another case which involved fraud in the amount of 10,000, and the accused person was sentenced to 10 years imprisonment. The state referred to the notorious case of Samson Mashata Paweni. We are still looking for the citation, but it is one case which occurred in the 1980s, and in our collection, it would be the only case which, in terms of seriousness, was of as much as of the same, considered to be the most serious. But clearly, this offense before us, as far as all the information that we have at hand, is one of the most serious, is the most serious case of fraud that the courts have had to deal with since independence, 45 years ago. As I've said, I will now relate to the principles that guide sentence in the guiding guidelines in arriving now in determining the sentence that should apply to this case. The sentencing guidelines are mandatory. We are required to take into account the objectives of sentencing, which are to rehabilitate, punish the offender, the extent in a manner which is just and proportionate. And all sentences must take into account, one or more of the following: reformation, that is to assist offenders to rehabilitate. Mr. Mugia submitted this, and we agree that reformation, rehabilitation is critical in this case. It's also achieved by suspending a portion of the sentence. It's also appreciated by shortening any prison sentence so that the accused persons are not exposed for too long to hardcore criminals. Retribution has come back as consideration in sentencing. Retribution is described as ensuring that the offender should face a sentence that is equal in measure to the harm he or she has caused. What this simply captures is public revulsion. This is the reason why, where the offense involves public funds, members of the public, citizens in general, expect a sentence which clearly shows its disapproval of abuse of public funds. And this presumptive penalty of 20 years is one of the most severe presumptive penalties in the schedule of presumptive penalties. And that clearly is informed by the expectation of society that people who abuse public funds should be punished. A court, we agree with the state, would be failing if it doesn't recognize the expectation of society. Deterrence is, Mr. Mugia referred to this. Is there any possibility of reoffending? Perhaps with respect to the accused persons, yes, they are, in their middle ages, and there is no likelihood that after this experience they may reoffend. That's a very forceful submission. But deterrence does not only relate to the accused persons, it also relates to society at large. Like-minded people should be deterred by the sentence that we are going to impose. And that of course relates as well to protection and prevention. Restitution is a very serious consideration. That is why it is given weight. So clearly, courts normally apply this or give this effect by suspending portions of that. That is also captured in the sentencing guidelines themselves. So all sentences must be proportional to the offense. There must be consistency, which is why we have this, the penalty. We have already taken into account the aggravating factors that are listed in the table in determining the presumptive penalty. But there are general provisions relating to aggravating factors and mitigating factors. These are the circumstances that we then take into account in considering whether to go above or below the presumptive penalty. Mr. Maduku took us through this. The State Council also took us through this. We agree. They are correct. That is how a proper sentence should be arrived at. Those that are considered as aggravating circumstances include, in this case, that benefit the accused persons are previous convictions, they are first offenders. Rather, I will repeat that. With respect to aggravation as submitted by the state, the accused persons are not repeat offenders, they are first offenders. So to that extent, they are not affected by that aggravating factor. Evidence of prior planning and premeditation, I have dwelt at length to the nature, the manner in which this offense was committed. That was careful planning. The offense was organized crime. Well, yes, because they are co-perpetrators to that extent. They acted as an organized game. Whether the offender targeted or prejudiced a vulnerable victim. This is what the state was at pains to explain, that they deprived the poorest of the poor. This is what the Mr. Mindurwa, who gave evidence on the victim impact, was at pains. So this aggravating feature is present. And where the offense was committed with repeated and gratuitous, this does not apply. Where the offender abused their position of power, authority or trust. It's broader now, his position of power. The second accused person said he's a member of the Central Committee of the ruling party. He said he's the chairperson of the EEG, which advocates, which lobbies for local companies. We said in our judgment that is a legitimate cause, but it must not be abused. It had no place in this case. He had no reason to even assert in this court that he attended a meeting concerning a performance of a government tender, wherein his position of power as chairperson of a political pressure group. That is completely misplaced. That's abuse of power. Whether the accused played a leading significant role in this claim, we have already said the first accused person played a significant and leading role in the commission of this offense. He said when I heard of this contract, I decided that this was an opportunity. I decided that we should submit a bid. I decided that the name Black Tech Livestock, I'm saying I because he was part of that decision as part of the board to submit the bid in the name of Black Tech Livestock and Poultry. He clearly played a leading role in attending all those meetings, in negotiating the prices, in purporting to perform. He even cancelled what he believed was the contract. He was clearly in charge of this. He played a leading role. His involvement was clearly aggravated. These aggravating circumstances would therefore persuade us to go above the presumptive penalty of 20 years. However, before we do that, we must now consider the mitigating circumstances submitted by Mr. Matuku. He argued forcefully, and I repeat, that there may be co-perpetrators, they may have been found guilty as co-perpetrators, but their roles are glaringly different. And the second accused person must benefit from a lesser role. We have said we accept that submission. Clearly, the sentencing guidelines themselves direct us to take that into account. But the other mitigating circumstances, as listed in the sentencing guidelines in section 9 of the sentencing guidelines, are missing. The only other mitigating factor is that the second accused person is the first offender, or that both of them. But then, they did not readily admit, so they can't benefit from that. They have not shown any genuine remorse. I have said we'll let the first accused benefit from the apology, but somehow, Mr. Cotton on his behalf continued to submit forcefully that there is no correlation, there's no relationship between the fraud and the prejudice. In any event, it's neither here nor there. Some people get employment as teachers using fraudulent qualifications. So, as far as is concerned, qualifying for a contract, a government contract using false qualifications, is not really anything serious. We believe that he was speaking on instructions, and if those are the instructions, there's no genuine remorse. In fact, the accused person started off by saying that on behalf of Black Tech and as a director, he apologizes until the prosecutor, reminded him that he was appearing in his personal capacity. That's when he apologized. So the remorse, yes, he will benefit, but it's not really as genuine as it ought to have been. Well, the second accused person benefits, as far as I'm saying. Likelihood of reoffending, that has been referred to. Evidence, the second accused person offered to restitute, and if ordered to do so by the court, obviously that is an intention to restitute. Having said that, we find that there may be need to distinguish between the accused persons, in the sentence that we are going to impose. the second accused person submitted at length in mitigation in the normal way. But the first accused person, whether it's his lawyer or his instructions, was clearly intransigent. But the second accused person, we were persuaded, by the seriousness of the mitigation. They are going to be attached to it is another. But we could feel that this was mitigation well motivated in terms of the principles that are applied to mitigation. So we also recognize that in terms of distribution of the proceeds, the state managed to prove that the second accused person got 200 million ZIG then, which we have converted to United States dollars at the time, and that has been the proven, his proven benefit. He may have benefited more, but as courts, we always give benefit of the doubt where issues are not clear. So there may be need to distinguish between the accused persons, and we did distinguish between them. I've already referred to the fines and so on. I've referred to the personal circumstances. The second accused person, as I say, submitted, in the usual way, genuinely. He was prepared to take this court into his confidence about his personal health. And, once that has been done, the court must take that into account. We are unaware of any health complications with regards to the first accused person. The state submitted that a sentence of 35 years imprisonment would meet the justice of this case. They suggested that this court could temper justice with mercy by suspending 5 years on the usual conditions of behavior, and 5 years, of that remainder, 5 years on condition of restitution, leaving an effective penalty of 20 years. We understand where the state is coming from. Over a period of 45 years, this is the most serious case that the courts, at least to the extent that we are aware, that these courts dealt with. We understand that abuse of funds has become a major concern, and corruption is a major concern. I say corruption, although we are not dealing here with, an offense called corruption. But if one pays regard to the standard bidding document, it actually mentioned that there should be no corrupt practices. And corrupt practices were then defined that the ministry, the companies were expected to be ethical in their conduct, in either securing the contract and in performing it. So clearly, unethical behavior is under the umbrella of corruption, particularly if it involves public funds. And there are several programs now that have been embarked on by the government to fight corruption, and so clearly there must be a deliberate shift towards imposing deterrent sentences when it comes to cases of this nature, cases involving partner, to deter. So we understand that's where the state, the state is coming from. We, however, accept that jurisprudence has shown us that the maximum penalty provided is always reserved for the most serious offenses. What jurisprudence tells us is that it's possible that the worst of fraudsters have not been born, so they'll probably be here in future, and we must reserve the maximum penalty to deal with such more serious offenders. Nobody thought that we would have a case of more serious than the Pawani case, but here we are. So jurisprudence tells us that more serious cases may still come. So we will abstain from imposing the maximum penalty. We also believe that the maximum penalty should also be reserved for repeat offenders. The accused persons here are first offenders, and it would be inappropriate to impose the maximum penalty on first offenders. That would breach the other values or purpose of sentencing, which I have already referred to. We have already referred to the mitigating circumstances. With respect to the first accused person, we find that the aggravating factors, the circumstances of his involvement in this crime are aggravated, and the aggravating factors, the general aggravating factors in Section 9 of the sentencing guidelines outweigh the mitigating circumstances, which is the reason for us to move above the presumptive penalty of 20 years. With regards to the second accused person, I have already said what we think about him, with regards to the mitigation that was made on his behalf. And we believe that there's justification to go below the presumptive penalty. There's also, as I've said, restitution where it has not been voluntarily made can still be made through an order, through some form of coercion. The sentencing guidelines tell us that a court that is pursuant to the provisions of the Criminal Procedure and Evidence Act, a court is empowered to suspend a portion of the sentence on any conditions that it deems fit. It may be one, it may be two, it may be more. In this case, we find a sound legal basis for suspending the sentence that we are going to impose on the accused persons, or the sentences that we are going to impose on the accused persons. Firstly, on condition of good behavior, because that's a way of deterring them. That's a way of rehabilitating them. When a sentence is suspended, it hovers above the head of the offender, and for a period of suspension, deterring them from repeating the offense. We aim to achieve that by suspending a portion of the sentence. It is up to us, and we have, in the exercise of discretion, considered that we should also submit a portion of the remainder of the sentence after the sentence is suspended on condition of restitution. Now, we then had to consider the rest, what we would order as restitution to be paid by the accused persons in suspending portions of sentences. The practice of this course, their case law, which appear in the judgment, is that the court must apportion the responsibility, the duty to restitute amongst the persons charged with the offense or convicted with the offense. Not charged, convicted with the offense. That's the normal trend. So where $10 is the prejudice, each should contribute $5 each. Each should contribute $5. It has been found to be an equitable way. Not saying one should pay the other to be absolved. It's a bit difficult. So we are going to adopt that approach. But ordinarily, as I have said, the court normally looks at the number of the people that have been convicted of offense and apportions the responsibility to restitute based on the number. That's dividing the actual prejudice by the number of people that have been convicted, as I've illustrated before. This is a unique case where the court is dealing with two accused persons. But in the evidence, it became clear that there were other offenders who were liable to be charged with the offense. We don't, we are now aware of Tinashe Chimombe. We are now aware of Black Tech Private Limited. We are now aware of Ajune Kabise. They are liable. They are not before us. They have not been convicted. So ordinarily, we would not be apportioning any duty. We can't, in fact, apportion any. We cannot, lawfully apportion any duty to restitute to them because they are not guilty. They are presumed to be innocent. They are, in fact, innocent because they've been charged. But we can't really not take into account that the facts in this matter point to their involvement. And obviously, possible benefit in this crime. Whether they're going to be charged is a different issue. But we decided now that in the exercise of our discretion, we can properly take that into account. And we will take that into account. I must emphasize, I'm not saying they are guilty, but I'm saying the facts before us point to their involvement. The accused persons have been convicted as core perpetrators, and the evidence points to other core perpetrators who are not before us. We must take that into account, and we will obviously, in apportioning restitution, take that into account. If we are wrong, we don't regret that, because courts must always err on the side of leniency. That is the jurisprudence that we have. With respect to overall punishment, as I've said, we start from the premise that they are all liable to a similar penalty. Then we deal with each individual. We had considered that a sentence of 25 years imprisonment would meet the justice of this case. But we take into account that the accused persons have been in custody for 18 months. And that period, when translates it to 27 months, if one takes into account the usual remission that, serving people are allowed at prison for good behavior. We accept the submission by the state that the accused persons were by and large responsible for the delay in completing this case. We say so particularly with reference to the first accused person. The judgment is very clear that at the end of the day, the first accused person admitted all that he was denying in this defense, which led me to ask Mr. Koto whether this trial was worth it, at least with respect to his crime. We even went as far as to say the first accused person trial could have proceeded on the basis of a statement of agreed facts, because his involvement was eventually admitted by him. There was no reason for him to, spoil this trial, call people names, attack the court, attack assessors, attack other people who may not be part of this trial, instead of concentrating on the offense that he was charged with. He clearly was to blame. But having accepted that submission, we still feel that he was in prison all the same. It was self-inflicted incarceration. In the process, he has been in prison for the equivalent of 27 months because of his conduct. But we must take that into account. We will. It's not really that strong, but we as a court, it's also the same incarceration. So we gave them a discount for that from the 25 years. And the second accused person, while we are not very sympathetic with the first, the second accused person must benefit from the fact that he's physically ill. Having said that, the accused persons will be sentenced as follows. The first accused person is sentenced to imprisonment for 22 years, of which 3 years are suspended for 5 years, on condition the accused does not, during the period of suspension, commit any offense involving dishonesty, for which, upon conviction, he is sentenced to imprisonment without the option of a fine. Of the remaining 19 years, 4 years are suspended on condition the accused person pays restitution in the sum of United States I would have to I will revert to the amount of restitution later because the figure here is not very clear. But I must say, the figure was arrived at as follows. We first of all deducted what we believe the second accused person benefited through Militech Enterprises. We then considered that three accused persons remained, who are the first accused, Black Tech, not quite accused persons, but people who were liable. The first accused, Black Tech Private Limited, Black Tech Private Limited, Ajune Kabisira, and Tinashi Chimombe. And then we divided that, his benefit by 3, and we ordered him to restitute that. So that is the figure that he must restitute as a condition of the 4 years that we suspended on condition of restitution. So the actual figure is literally that figure which will appear in the judgment, and we have suspended 4 years for that purpose. That leaves an effective imprisonment of 15 years for the first accused person. I have already indicated that with respect to the second accused person, we are persuaded that there is a sound basis to go below the presumptive penalty. He is sentenced to imprisonment for 17 years, of which 3 years are suspended on condition, are suspended for 5 years on condition that during the period of suspension, he does not commit any offense involving dishonesty, for which, upon conviction, he is sentenced to imprisonment without the option of a fine. A further, out of the, of the remaining sentence of 14 years, 2 years are suspended on condition that he pays restitution through the registrar of this court. I have already indicated that we will give him that benefit in terms of lesser benefit. What has been proved to have gone through the account of Militech is what we are going to order him to restitute. We have converted that to United States dollars at the time. It converted to 964,024 United States dollars and 64 cents. This is the amount that he must restitute through the registrar in order for him not to serve the 2 years that we have suspended on condition of restitution. That leaves him with an effective sentence of 12 years, hoping that my calculation is correct. They say lawyers are very bad at figures, but I hope I got them right this time. The order, the full amount, the actual amount of restitution to be made by the first accused person will appear in the order. We should be uploaded on the because it's a bit not clear, smudged on the document that I'm reading. So there should be no prejudice to that. I hand down that sentence.
As the court pleases.
Any other business?
Yes, indeed, my lord. Yes, my lord, our instructions are to proceed in terms of Rule 94, Sub Rule 1A of the Rules of this Honorable Court, in respect of which, in part, my lord, my instructions are to apply for leave to appeal against part.
Wait a second. I'm looking. Oh. This one. This one is good. But maybe just before you proceed, Mr. Jetero.
Yes, my lord.
We are aware of the accused person's right to make an oral submission for you. I'm sure it's leave to appeal.
Indeed, my lord.
What does he want to appeal against? Conviction and sentence?
Yes, my lord. Part of his grounds of appeal, some are against, they are or both against conviction and sentence, but some of the grounds of appeal are only in respect of the findings in law, and some of the grounds are in respect of findings of both law and fact, and then some against findings in fact.
Okay, thank you.
Yes, my lord.
Let me hear from Mr. Mpofu.
My Lord and Lady Attendant Professors, we have similar instruction,
Yes.
and we are in the same position, but for us more, it's a mixture of law and facts, so we need leave. But we are appealing against both conviction and sentence.
Yes. Okay. Very well. As I was saying, I'm aware that in terms of the rules, offenders or convicted persons are allowed to make oral application for leave to appeal in an appropriate case. As you say, this is an appropriate case where such leave is required, and which right must be respected. I'm also aware that if that application is not made, it can still be made in writing within the period stated in rule. Is it rule 94?
In terms of rule 94 sub rule 2.
Yes, of the High Court rules.
Yes, my lord.
My direction is that the convicted accused persons should submit their application in writing within the time frame that is stated in the rules, and the state will also respond in writing.
As the court pleases, we do take note, my lord, that in terms of the sub rule 2, though, it would then require an additional requirement of an explanation of why the application was not made immediately after the decision had been pronounced.
Yes, because the court has directed that.
Yes, indeed, yes, that is the explanation.
So you actually have, I actually have allowed that the application be made in writing. So you won't, you probably need only state that.
Indeed, my lord.
That was the direction of the court.
Indeed, my lord.
Yes. So yes, but it has to be within
the 12-day period.
You know that as the rule proceeds, it says if you don't make it within, is it 12 or 14 days? I'm not sure.
12 days, my lord.
12 days.
Yes, my lord.
Then after that, you need condonation.
Yes,
I'm hoping that it doesn't get to that extent. I'm actually directing the parties to make their application writing within the time frame that is stated in the rules, which is we all know to be 12 days.
Indeed, my lord, we do take note of that. Maybe that then just on the occasion of the first accused person, maybe just leaves us with one housekeeping issue relating to the judgment, my lord. We do take note that there was another judgment that was uploaded on the 4th of December, which was a correction of the one that was uploaded on the 1st of December. Yes, my lord. And that there is an extempore judgment of this honorable court on the 22nd of November 2022. I just wanted to seek clarity from this honorable court in respect of the date.
Well, I'm sure we all know that the extempore judgment was given in terms of the Criminal Procedure and Evidence Act, which requires all judgments in criminal matters to be read out in an open court.
Indeed.
It is also the practice of this court that after an extempore judgment, the court may then produce a judgment for circulation, which is always the version that the parties should really work with. Because an extempore judgment contains some slips, and so on. So the actual judgment for circulation, the judgment which normally work with, but there is a corrigentum which is attached, unless you missed it.
Indeed, we had
which was uploaded with the judgment, which you say was uploaded.
On
it was
the
just
4th, yes,
to correct typographical errors. And I think that is in accordance with practice in these courts. It was not really like to change the ratio of the judgment, but just to correct typographical errors. You can imagine that judgment was uploaded under pressure. The accused persons were placing the court on terms, which is very unusual. but it happened. But after producing that judgment, after reading it, I realized that there were so many obvious patent errors. These are harmless errors, which would